Word. So what is? That's good.
Cato is in.
This is out to the 17th.
The Mario Davis. Yeah. Yeah, for PCC?
Yeah.
Yep, I got 3. The first 3, Bonds, Cato, and Davis. Huh? Sorry, Judge.
Okay. Also going to be gone 4th through the 11th, right?
Huh?
So we're going on vacation. I'll be gone for 2 weeks now.
You said April?
August.
Oh, what's
So
up
it's
with
4th.
you? April?
Huh?
You said April.
You said April.
So it's happening in April.
What must be happening in April? Okay, you said August what, Judge?
I'll be gone 4th,
Uh-huh.
then the week of the 7th to the 11th,
Already.
and the 14th.
14 through the 18th. All in August?
Yeah.
Okay.
And I got it all covered except for the 11th.
Except for Friday.
Yeah. except for-
Yeah.
Something's
Right.
not working, that's what.
But I'll schedule for the 7th to the 11th, and they're gonna have to schedule for next week. So let's make sure to tell them no more than 2, 3 exams, so off 9 to 5.
Oh,
And the
okay.
rest of them put off on the following week. or
Okay.
whatever. Okay? We'll just deal with it.
Sounds good.
I also have I need dockets for the 17th to the 21st.
You probably got it set.
Hmm?
You probably got it set. Yeah, there you go.
Yeah.
I'll do a copy of that.
And,
Oh, there's something. Okay, sorry.
Good morning.
Good morning.
I'm prosecutor on Genesis Sims, which
Okay.
I know that she's.
Yep, she's on, and it looks like her client is on.
Okay, I'm hoping my intern gets here, because she wanted to do it. Oh, look, there's Sue Dunn. I haven't seen that people waiting in so long.
Oh, Ms. Dunn.
She's, I miss her. I don't see anybody since I'm at the beginning.
Oh, your P number?
51260.
How long you been at the agency?
3.5 years,
Oh.
but, 2 of those years, everything was shut down. I
Yeah.
got there and like 3 months later,
Oh, COVID.
COVID hit, so. And I don't normally get here, so.
Oh.
Hello, Miss Grand.
So I will sit down, hope that Lexi gets here.
Okay. Good morning, Mr. Cohen.
Good morning.
You're on, Cato, correct?
Correct. If he's
All right. I got your
whenever,
discovery put in the file.
okay,
Your client
thanks.
is in Wayne County Jail.
Correct. I was just hoping to have a quick breakout room with him.
He's not on yet. I think this is Davis on.
Yes.
Okay.
Wayne County Jail, is that, Demario Davis?
Yes, ma'am.
Okay. So, Mr. Cohen, do you want to wait on your client?
Yeah, if that's okay, I'll just wait for him.
Okay. Mr. Roberts.
Good morning, Madam Clerk. How are you?
Good, how are you? Who are you
Doing well,
on?
thank you. I'm here on Raymar Bounds. And
All right.
Madam Clerk, I was wondering if the court had a phone number for Mr. Bounds. There wasn't anything on the appointment papers, and we ran a TLO, but we couldn't find a good number.
Let me see what I got. Oh, it says no phone number.
Okay.
It says no phone number for him.
Okay. Thank you, Madam Clerk.
Do you want to try to wait on him?
Yes, I'll try to wait. I'll just stay in the Zoom.
All right, because I don't see him in the waiting room right now.
I can stay on until Your Honor needs to do other matters. So that's fine with me, Madam Clerk. Thank you.
Okay. Good morning. Anyone else need to check in?
Good morning, Madam Clerk. This is Robert Cantor. I've got a PCC on Demario Davis, who's in the Wayne County Jail.
Yes, he is on right now. Did you need to go in a breakout room with him, or you ready to go?
Could I go in a breakout room with him very quickly?
Sure. Mr. Davis, I'm gonna put you in a breakout room with your attorney, okay?
Yes, ma'am.
All right. Good morning. Anyone else need to check in that has not checked in? All right. Courtroom 233, Judge Giles courtroom. How may I help you? Good morning.
I was gonna try to wait for my intern, but she's not coming, so I'm ready to go. That's it.
Yes, that's correct. Ma'am, what's your question? I have the case number. I'm not sure about that. I don't know, you have to speak to him, I don't know what he has. You have his attorney, you have his attorney's phone number, is that correct? Ma'am, you need to contact his attorney if you want to speak to him. All right. You're welcome. You too, thank you. I took out. I got it. Yeah.
36th District Court for the City of Detroit, State of Michigan is now assessed with Honorable Judge Ronald Giles. Recite.
Calling case number 2357650, the people of the state of Michigan versus Lisa Moped. Defendant is charged with count 1 and count 2. Controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Habitual offender, third notice. This matter is scheduled for a probable cause conference.
Good morning, Judge. Giles on behalf of the people, P number P86590.
Is this on Ms. Moffett? I apologize.
Yes.
And good morning, Judge. Neighborhood Defender Service by Andrew Sullivan, P84261, here on behalf of Lisa Moffett. I've attempted to reach out to Ms. Moffett, but the number that's listed on the appointment sheet is not in service. So I'll have an investigator try to make contact with her. If we could just schedule this for a preliminary exam, perhaps a little more than a week away, to make sure that I make contact with her before that.
All right, now it's scheduled for Monday, July 17th at 9:15. She knows she has this case, so she's responsible for getting in contact with you or finding out when her dates are.
Sorry, Judge, when did you have it scheduled?
9:15 on July 17th.
Is it at all possible to try the 19th?
Nineteenth at 9 o'clock.
That's fine, Judge. Thank you.
Okay, that's me. I don't have my judge job.
Anything else?
Nothing else for the defense, Judge. Thank you.
All right, thank you.
Log off of courtroom 233. Log into courtroom 4. Judge Ronald. Okay, that's so. So instead of 233, 4-0. Okay, but you have to log out of 233. Yes, I see you're in here twice. You have to log off both devices. More 0. You're not gonna put in 233 because you're going to go. You're welcome. Parties ready on Genesis Sims.
Yes,
Calling
ready.
case, calling case number 2356817. The people of the state of Michigan versus Genesis Sims. Defendant is charged with count 1, embezzlement, agent or trustee, $1,000 or more, but less than $20,000. This matter is scheduled for exam.
Good morning, Your Honor. Dean Bria, P51260, Assistant Attorney General on behalf of the people.
And good morning, Tiffany Howe on behalf of Ms. Sims, P79667.
How you to turn on your video, please?
1 second, Judge.
Ms. Sims, can you state your name for the record?
Genesis Sims.
Thank you. Ms. Howe?
Hold on 1 second, Judge. I gotta get a jacket real fast. I'm sorry, hold on. Yes. Your Honor, at this time, I've spoken to my client and I explained to her that she has a preliminary examination and the burden that the people have to prove. And it's her decision if she wants to waive her preliminary examination.
You have any objection?
No, Your Honor.
Thank you. All right, Ms. Sims, can you state your name again, please?
Miss Genesis Sims.
All right, Ms. Sims, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause the crime was committed and probable cause you had something to do with committing that crime. You understand that?
Yes.
Has anybody promised you anything or threatened you in any way to get you to waive your right to preliminary exam?
No.
You're waiving your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes.
Do you have any objection to the court signing your name to the waiver form and initialing off?
No.
All right, Ms. Howell, do you have any objection to the court signing your name to the waiver form and initialing off?
No.
All right, court will find that you freely and voluntarily waive your right to preliminary exam matters bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be July 24th, 2023, 9 o'clock.
Judge, one thing, my client has a trip that she has already booked and planned for her daughter's birthday. This is a trip in which she would have to travel to Orlando from what are the dates, Ms. Sims?
The 13th through the 18th.
The 13th to the 18th.
July 13th.
July 13th to the 18th, Judge. And we are asking for the court's permission for her to be able to travel with her family to Orlando to celebrate her daughter's birthday.
People would have no objection.
All right, court's going to grant the request for travel out of state. Ms. Howell, you just need to submit an order, all right?
Yes. Yes, and you said the AOI date is the 24th?
24th, yes.
Okay, thank you.
All right, you're welcome, thank you.
Your Honor, you need to initial the waiver form.
Oh, yeah, you can.
And it's so nice to see everybody.
Yeah.
It's been a long time.
All right, Ms. Sims, you can hang up.
The other side of the coin, but it's really the same exact work I was doing before, which is a good match for me. This is an aberration. Have a good day.
Yeah.
Parties ready on Demario Davis?
Defense is ready.
Calling case number 2357090, the people of the state of Michigan versus Demario Davis. Defendant number 2 is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 3, police officer assaulting, resisting, obstructing, habitual offender, second notice. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Morgan on behalf of the people, appeal number P86590.
And good morning, Your Honor. Robert Cantor, P24993, appearing on behalf of Demario Davis, who is present via Zoom.
Mr. Davis, can you state your name for the record, please?
Yes, Your Honor. Mario Deshaun Davis, Your Honor.
Thank you. Counsel.
Your Honor, I've discussed this matter with Mr. Davis. He is requesting that a preliminary exam date be set.
July 17th at 9:15.
That would work, Your Honor. Thank you.
Thank you.
I'll be in touch with you, Mr. Davis.
All right, thank you.
Yep.
Yes, sir. That's all we have to do.
All right, Mr. Davis, you can tell the deputies we're finished. You're
All right,
finished.
Your Honor. Thank you. I appreciate you.
Okay, take care.
Wayne County Jail, who do we have?
Back came up.
I'm sorry, is that Cato?
Yes.
Oh, okay. I'm gonna put you in a breakout room with your attorney right now, okay?
Okay.
All right, there we go. Walter. Mr. Willis,
Yes.
all right, we're waiting for your attorney, okay? So you can put your device on mute right now until we call your case.
All right.
Thank you. All right. Who is this? Derek. Let's see.
What was the date and time for Davis?
July 17th at 9:15.
Perfect.
Oh, here we go. You ready? Calling case number 2357639, the people of the state of Michigan versus Mac Cato. Defendant is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, assault with a dangerous weapon, felonious assault. Count 4, count 5, count 6, weapons, felony firearm. Habitual offender, second notice. This matter is scheduled for a probable cause conference.
Good morning, Judge Giles on behalf of the people, P number P 86590.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing by Zoom with Mr. Cato, who is present from the Wayne County Jail by Zoom. Mr. Cato, can you please state your name?
Mac Marvin Cato.
Pleasure, Mr. Cohen.
Your Honor, housekeeping, I submitted a motion and proposed order for discovery. I do have paper and some digital discovery, but it looks like probably body worn camera, audio and video of some of the witnesses' statements in this case that I was not provided with.
I'd like to address that discovery order. I'm standing in for attorney Laura Narcessi, who will stand in, addressing that discovery order. Specifically, they have access to all witnesses that will be called at the exam and discovery. That was part of your discovery order. Criminal record of defendant is available to them.
Wait. Do it one thing at a time.
Okay.
So there's no way I'm gonna remember everything you just told me. Saying that they have access to witnesses at the exam.
They have access to the witnesses that will be called in the exam through the discovery package.
What do you mean in the discovery package? So they have information on how to get in contact.
They have access to.
That's not my question. Listen to what I'm asking you. You're telling me that they have in the discovery packet information that will allow them to contact the witnesses? All right, which number are we talking about now? On the
discovery order?
On the motion. Order.
This will be A. I'm addressing A with.
A. Yeah.
For the discovery order.
Name, address of all lay and expert witnesses of the prosecution and the following.
I'm sorry, Judge.
Okay, A says the names and addresses of all lay and expert witnesses that the prosecution intends to call the exam. Cohen?
No, she don't like hear. She don't like to hear everybody.
Mr. Cohen?
Yes, Your Honor.
Okay. Names and addresses of all lay and expert, we call any expert witnesses?
I'm standing in for Laura Narcessi.
So you don't know?
I don't know.
You can't address the order? If you don't know, you can't address it. There's no use in going through it.
She provided me.
I didn't ask you that, counsel. I don't care what she provided you. I'm asking if you have certain information that would allow me to address this motion, and you're bouncing all around it.
Wait, no, answer. I'll have Laura Narcessi answer the questions about the discovery.
Okay, when?
We'll email her and let her know.
That's not satisfactory. I have a motion before me. I'm about to set this exam. I have to deal with this issue.
Can I see if she's in the courtroom today?
Yes.
She's in the doctor's office, so.
What?
She's in the doctor's office.
She's not available.
No.
Well, when she's gonna be available?
I could give her a phone, I don't know.
She ain't working. She's back. I don't like one of them.
Mr. Cohen, what can you use the right to ask for all lay names and address? You had a name, but the addresses of all lay witnesses. This is an assault case, especially without a protective order.
Your Honor, I would be happy not to provide any contact information to my client or anyone outside of our office. But the
Oh, wait,
contact
hold
information.
on. I didn't notice the prosecutor just walked out.
Okay.
Talking with the attorney, she asked if it could be motion up for tomorrow and be done via Zoom.
Can you come back on tomorrow to deal with at 8:30 to deal with the issue of the motion, the discovery order?
I can. That's no problem.
All right. Interim, let's set a date, please. You're available at July 17th at
Judge, that date doesn't work for the 18th, the 20th, and the 21st.
I said, well, July 17th is what I said.
The 17th doesn't work for the attorney with Florida and assessing who's going to be doing the case.
So the 18th is good.
18th, the 20th, and the 21st is good.
You're available the 18th at 9:30?
Yes, I can do the 18th at 9:30. And Your Honor, the last thing I wanted to do this morning for Mr. Cato was make a request for a 10% provision for the bond on this case.
I'm gonna do that.
And I'm sorry, and also to ask for a DSU or pretrial services report referral in the event that the court, well, regardless, I guess, so that we have that available to us, hopefully at the exam.
Okay, Mr. Cato had a bond redetermination hearing on July 3rd. In front of Judge McConaughey, Judge Williams stood in for Judge McConaughey.
Yes, Your Honor, my understanding is the bond was ordered to remain the same at that redetermination hearing.
All right, well, what's changed since then?
Well, Your Honor, this is my first opportunity as Mr. Cato's counsel to make represent.
My question, Mr. Cohen, you have to tell me what has changed since Judge Williams made his decision to keep the bond the same. I have the same authority as Judge Williams. I don't have authority that supersedes his. So unless you can give me additional information that he didn't have, then I can't change his bond. I can give you a DSU and we can readdress it then, but I have to have additional information.
Understood, Your Honor. I do not know what information was provided to Judge Williams at the bond redetermination hearing, so I can't speak to whether the information that I would provide on behalf of Mr. Cato to this court this morning would be additional information or not. I think the court does have authority, both statutorily as well as under the, I'm trying to remember the name of it, the bond partnership agreement to address bond at the probable cause conference. Notwithstanding the fact that bond has been addressed both at arraignment and the bond redetermination hearing.
I don't know nothing about no bond agreement.
There was a
I'm-
settlement.
I'm aware of that. I'm aware of that settlement. But I'm telling you, that does not give me authority to change Judge Williams' bond without having additional information. So at this point, I'm not going to change it. I will give you the issue. I will readdress this at the exam. If that's what you want, once you get to DSU. But other than that, I'm not gonna change it at this point.
Understood, Your Honor.
All right. Anything else?
No, thank you, Your Honor. Not for
No,
the
Judge.
defense.
All right. We'll be back on the 18th.
And also still tomorrow at 8:30?
Yes.
Thank you.
Yes.
Have a good day, everyone.
On the issue. Okay, yeah,
Thank you.
thank you.
Where Mr. Oh, there he is. Mr. Roberts?
Yes, Madam Clerk.
Okay, you ready? Your client is on, he's in Wayne County Jail. Division 2.
I am ready. If I could get a breakout room with him before,
Sure.
thank you.
Ms. Dunn, your client still hasn't logged on. Nobody's in the waiting room.
Okay. If you want to call it, Madam Clerk, I don't have any reason to wait.
Okay. Calling case number 23-57652, the people of the state of Michigan versus Duran Young. Defendant is charged with count 1, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Habitual offender for notice. This matter is scheduled for a probable cause conference.
Good morning, Judge. I was wondering on behalf of the people, P number P86590.
Good morning, Your Honor. Susan John P. 58696 on behalf of Durand Young.
All right, waive his appearance for the purpose of this hearing.
Yes, Judge.
Thank you. All right, send this matter for exam.
Yes, Judge.
July 17th at 9:45.
That'll work. Thank you, Judge.
Thank you.
Good morning, Mr. Quinn.
Good morning.
You ready? Your client is on.
Yes, I'm ready.
Calling case number 2357647, the people of the state of Michigan versus Walter Willis. Defendant number 1 is charged with count 1, stolen property, receiving and concealing motor vehicle. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Wang on behalf of the people, P number P86590.
Good morning, Judge. Christopher Quinn, P69483, appearing on behalf of Mr. Willis, who's appearing via Zoom.
Mr. Willis, can you state your name for the record, please?
Yes, my name is Walter Trekshawn Willis.
Thank you. Mr. Willis, so you know in the future, please wear a shirt with a collar. In court, I don't do sweats, I don't do t-shirts, all right?
Okay.
Okay, thank you. All right, Mr. Quinn, you have, send this for exam.
Yes, I have the discovery and we'd like to set the matter for exam.
All right, are you available July 17th at 10 o'clock?
Yes, I can do that.
All right. All right, anything else?
Oh, that's it, Judge. Have a good day.
Thank you, too.
Thank you.
All right. Mr. Willis, that's in-person exam. So you're in court on the 17th, 10 o'clock. Thank you.
Thank you. We did bounds, right? We did bounds.
No, they're in a breakout room.
Oh, that's Mr. Roberts.
No.
You ready, Mr. Roberts?
Yes, Madam Clerk, thank you.
Yeah, try bringing him in, I guess. Yeah. Yeah, I tried it too. Oh, there it is. All right. You ready? Calling case number 2258567, the people of the state of Michigan versus Romar Bounds. Defendant number 3 is charged with count 2, police officer fleeing 4th degree vehicle code. Count 3, police officer assaulting, resisting, obstructing. This matter is scheduled for a probable cause conference.
Good morning, Judge Alex Warren, on behalf of the people, P number P86590.
And good morning, Your Honor. Jonathan Roberts, P86428, on behalf of Mr. Bounds, who is present by Zoom. Mr. Bounds, could you please state your name for the court?
Ramar Bounds.
All right, thank you. Send it back for exam.
Yes, Your Honor. If we could get a July 18th or 19th date, if there's availability.
Roberta Archer. Okay, she's in Portland, 3. This is 2.
Tuesday, July 18th at 10 o'clock.
Yes, Your Honor, thank you.
Anything else?
That's all from defense, Your Honor. Thank you.
Thank you. Conclude the hearing.
Thank you. And Mr. Bounds, like I said, I'll see you Wednesday or Thursday.
All right.
Calling case number 2357541, the people of the state of Michigan versus Anthony Wheeler. Defendant is charged with count 1 and count 2, controlled substances, possession cocaine, heroin, or another narcotic less than 25 grams. Habitual offender for notice. This matter is scheduled for exam. Defendant has failed to appear.
Morning, Your Honor. This is Danny Ducat on behalf of the people, P number 86690.
Good morning, Your Honor. Neighborhood Defender Service Betrayed by Natalie Loves, P83355, appearing on behalf of Mr. Weiler.
Got any contact with him?
Judge, I don't have any explanation for his non-appearance this morning.
And Judge, people motion for KPS this time.
All right, KP shall hearing, previously submitted shall be forfeited. The bond set 30,000 cash.
Thank you, Judge.
Thank you.
Take care.
More. See. Calling case number 2357343, the people of the state of Michigan versus Rinja Taylor. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. This matter is scheduled for exam.
Good morning, Your Honor. This is Dan Duquette on behalf of the people, P number 86690.
Good morning, Your Honor. Good morning to your staff. Ted Wallace, P809222 on behalf of Ms. Taylor, who stands to my right. Ms. Taylor, please state your name for the record.
I'm sorry.
You gotta speak up.
Renee should take, I can't find this stuff. I'm sorry. Renee should take.
Right, yeah, thank you. Ready to proceed?
The people are prepared to proceed, Your Honor.
Defense is ready, Your Honor.
And the people will call Jamie Coleman.
Shane Coleman.
I said, stop, please. Raise your right hand. Swear or affirm to the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Right, for the Lord, according to the All right, Ms. Coleman, things first, I'll do t-shirts, and I certainly don't do shorts in my courtroom.
Okay, I'm sorry.
You dress the courtroom. Okay? All right, thank you. You're gonna be asked a series of questions. First by the prosecutor, defense attorney will probably ask you some questions. And then I may or may not ask you questions, all right? You have to answer all your questions out loud using words. You just can't shake your head. I say, that's a yes, no, whatever the answer is, okay?
Okay.
Also, I need you to listen to the question, just answer the question and stop. So if it's a yes or no type question, just say yes or no and stop. If they need additional information, they'll just ask you another question, all right?
Okay.
We all have a tendency when we want to talk about, when we talk about something, especially that may have been traumatic, we tend to ramble. You know, we want to get it all out, so we say this happened, this happened, this happened, this happened. We go, you know, just so we can get the whole story out. If you do that, I'm gonna miss something. If I miss something, I might not make the right decision, okay? That's why we proceed by one question, one answer. That way I can understand it. I know nothing about this case. The only thing I know about this case is the defendant's name and what she's charged with. Now I know your name. I get all my information from what happened in court. That's one question, one answer. All right? All right, thank you. You may proceed.
Thank you, Your Honor. Ms. Coleman, could you please restate your full name for the record?
Shane Coleman.
Thank you very much. All right, Shane, I want to take you back to June 12th of 2023, specifically the address 19433 Huntington Drive. Are you familiar with that address?
Yes.
Okay. Is that address in the city of Detroit and county of Lane?
Yes.
Okay. So at 19433 Huntington, were you at that address around 6:30 p.m.?
Yes.
Okay, and why did you go to that address on that date at that time?
Because my cousin had posted my 14-year-old daughter, excuse me, calling her out her name.
Now you said posted, what do you mean by that?
On Facebook.
Okay, so your cousin posted something about your daughter on Facebook, and you went to this address, is that correct?
Yes.
And why did you go to that address?
To talk to her, but she wasn't answering the phone. To talk to her, ask her why did she post my child.
Okay, and this person that you refer to as your cousin, do you see them in this courtroom today?
Yes.
Okay, could you please point to them and identify them by article of clothing that they're wearing?
She's right there with a pink and white jacket, ponytail on her head.
Thank you. And Your Honor, may the record reflect you've identified the defendant in this case. Thank you, Your Honor. So after arriving at that address, what happened next?
She was in the door. She was in the door with her phone on live, with knives in her hand.
Back up just a little bit. You said, so you arrived at this address and in the doorway, she is there. You said she had what in her hands?
About 3 or 4 knives in her hand.
3 or 4 knives.
Yes.
Okay. So did you two speak at that time?
Yeah, we were going back and forth.
Okay, what were you discussing?
I asked her, why did she post my child? She said, cause I can. She shouldn't have had on what she had on.
Okay. So.
Question answered.
So at that point, you two are discussing this post on social media. Does this conversation become heated?
Yes.
Okay. When this conversation becomes heated, what happens?
She got to throwing canned goods at me. I got to throw them back at her. She just threw one. I turned around to go pick it up and I fell. And then that's
So
when
after falling, so you went to pick up the can and then you fall. What happens to you next?
she's charging at me to try to stab me.
Okay, she's trying to stab you. Did you see what she was trying to stab you with?
A knife.
Okay, and did she make contact with your person using that knife?
Yes.
Okay, whereabouts on your body did she make contact?
In my right leg.
Your right leg?
Yes.
Okay. No further questions at this time, Your Honor.
Good morning, Ms. Coleman.
Good morning.
How are you?
I'm fine.
Good. I'm gonna ask you a couple questions, and if you don't understand them, just tell me you don't understand it. They should just, the answers should be relatively easy, yes or no.
Okay.
So on this, at this address at 19344 Huntington, whose house is that? It is a house, I'm sorry, correct?
Yes.
And it's Renijah's house?
Yes.
And you're saying you hadn't talked to Renijah before you came over there?
No.
So you showed up at her house and she just knew that you were there?
Yeah.
She knew you were coming?
Yeah, I called her. Oh, I'm sorry. Go ahead.
So you did call?
Yeah.
And you did tell her you're coming over?
No, she didn't answer.
Okay, so I'm confused because you said she knew you were coming, right?
Yes.
How'd she know you were coming?
I mean, she heard what was going on. She didn't know that I was coming over there to talk to her.
Okay, so you don't know, right? Because you can't tell me that she knew something if you didn't talk to her, right?
Yeah.
So you did talk to her, didn't you?
No, I did not talk
You
to
didn't
her.
tell her you were coming over?
No, I didn't.
Okay, so you came over and you wanted to have a discussion with her, right?
Yes.
A discussion about her saying your daughter was wearing something inappropriate, isn't that true?
Correct.
And you thought it was appropriate to bring your daughter over and get into a fight with her, right?
That wasn't what I went over there for.
You didn't go over there to go for a fight. All right, so when you showed up, where did you park?
In front of her house.
You parked in front, and who were you with?
My two daughters.
You were with your 2 daughters, and nobody was talking about fighting, right?
No.
Okay. You're aware that she was recording the whole thing, correct?
Yes.
Okay. And so you stand by the fact that you never said anything about fighting?
Yes, I do.
Okay. And she had knives in her hand?
Yes.
And hadn't she just recently had a C-section?
I don't know.
You don't know? She's your cousin, right?
Right.
Okay, so you don't know how she knew you were coming, but she's standing in the doorway with knives.
Correct.
But you didn't know she just had a C-section.
I know she had a baby. I don't know if she pushed it out or if she had a C-section.
Okay, and so where were you when you first saw her standing in the doorway?
In front of her house.
Okay, when I'm saying in front of her house would be across the street. Where were you standing?
In front of her walkway, her porch here, and I'm here in front of her house.
Were you on her property?
Yes.
And how far away was she?
She was in her door and I was at the end of her walkway. So I mean, maybe, I guess what, 5 feet?
5 feet? From the end of her
I'm not
walkway?
even at her porch. She was in her porch and her door. I was at the end of her walkway. I don't know how many feet that is.
So how about from me and you?
About our distance, yes.
Okay, and this is in your eyes, this is 5 feet?
Yes.
Okay. And so you saw she had those knives,
Wait,
right?
hold on. Approximately 15 feet.
Correct, and I would agree with that. So but in your testimony, it's 5 feet, correct?
I just said, I don't know how many feet, but the way you are and where I'm at, it's about that.
Okay. Well, how tall are you?
I'm 5'2".
You're 5'2". Would you agree that the distance between myself and you is substantially farther than your height?
Yeah. Yes.
So it was a lot farther than 5 feet, correct?
Yes,
Okay, and she had these knives in her hand when you were standing there, correct?
yes,
And she was telling you not to come up on her, correct?
yes, that's what stopped me why I didn't walk up, because she had the knives in her hand.
Okay, and so she clearly wasn't trying to have a discussion with you, was she?
I guess you could say that.
Okay, and so you go up to her house, correct?
Correct,
And you see her standing in her doorway, correct?
correct.
And she had just had a C-section, correct?
If you say so.
She didn't.
Understand, Your Honor. And she told you that she had no intention of having a discussion with you, didn't she?
No, she didn't.
She didn't?
No.
Well, you were under the understanding she didn't want to have a discussion with you, weren't you?
Yeah,
And so you, instead of just leaving, you continued to push forward, didn't you?
I continued to talk back and forth with her, yes, I did.
But you didn't argue with her?
I mean, if that's what you wanna call it.
You didn't threaten her?
No, I didn't threaten you.
Okay. So it's your testimony that someone talked about your 14-year-old daughter, and you never talked to her, but showed up at her house and were only there to have a rational conversation.
Correct.
Okay. And at what point did you go farther onto her property?
Which means I didn't go any further because she had knives in her. Why would I go forward?
So-
She has knives in her hand.
So it's your testimony that she took off from the porch and ran at you and started fighting?
Yeah, we was throwing stuff back and forth at each other. She came out the house telling me to get off her property. She was throwing cans at me.
Just throwing cans at you?
Yeah, cans.
Okay. And you didn't leave?
No,
Why not?
because I threw the stuff back at her. We was going back and forth.
But you just want to have a discussion, right?
If that's what you wanted to call it.
No, you said that you just wanted to have a discussion.
Yes.
So when it was apparent that there's not a conversation to be had, why didn't you just leave?
I don't know.
So you stayed to escalate this supposed conversation?
No.
No? Well, then
I
why?
mean, yes, I stayed till we both was having a conversation.
Well, she lives there.
Okay,
So why didn't you just leave?
I didn't. That don't give nobody the right to stab me.
Okay, but you were on her property.
I didn't have nothing, she wasn't threatening me. I didn't have no weapons in my hands, so it was no reason for her to stab me.
You just said you didn't know she had a C-section. How do you know she wasn't threatened by you?
Threatened by me for what reason? There was nothing in my hands that I don't pull up with no knives in my hands. I didn't pull up with no weapons in my hands, so there was no reason to be threatened by me.
And so you went to her house.
Yes, we already discussed it.
Yeah, I've heard that at least 8 times.
I understand, right? And when you saw those knives, you continued to stay.
We already discussed that too. I said, yes, I did.
And when you got in this fight with her, you were on her front yard, right?
Correct.
Okay, no more questions.
Briefly, Ms. Coleman, who threw the first can in this altercation that you had?
Ronald did.
And did you seek medical treatment for the injuries you sustained as a result of this
She didn't
incident?
say she sustained any injury.
I can lay a foundation, Your Honor. Did you sustain any injuries from this altercation?
From the going to can or from the whole thing?
The whole thing?
Yes,
Okay, and what injuries did you receive?
I was stabbed in my right leg.
Okay, and did you receive medical treatment for that stab wound in your right leg, excuse me?
Yes, I did.
Nothing further, Your Honor.
Anything else? Any other witnesses?
No further witnesses from the people, Your Honor.
Vince?
No witnesses for the defense, Your Honor.
The people would move to find over on all counts at this time on count 1, Your Honor. In this circumstance, we have Ms. Coleman who was stabbed after going to her cousin's house, after having a conversation over a social media post. There was no answer on the phone. There was an altercation that had occurred there, yes, but at some point it was escalated by the defendant in this case, who actually stabbed Ms. Coleman in the leg with a knife. And for those reasons, the people have moved to find over on count one.
If I may, Your Honor, Ms. Coleman testified that she showed up at my client's house, and she says that she's just there to have a rational conversation because my client posted something on Facebook about her daughter. If that's to be believed that she was only there for a conversation, then once it was clear that there wasn't a conversation that was gonna happen, she had all the opportunity in the world to turn around and walk out of there and leave. But she didn't. She continued to stay there. And she saw that my client had knives in her hand and continued to move forward and to get into.
No, there's no testimony about her continuing to move forward.
I'm sorry, she continued, she stayed there and proceeded to get into a physical altercation with my client on my client's property. My client had just got her, scratch that. There's an element to felonious assault, and I believe it's the third element, which talks about whether or not the defendant had the ability or was perceived to have the ability to commit a crime. When Ms. Coleman showed up, my client was in her doorway, as was testified, standing on her porch, and as Ms. Coleman testified, saying that she had no intent on being in a discussion or wanting to get into anything with her. But Ms. Coleman continued and got into it with her. But when Ms. Coleman saw my client, they were at least 15 feet away from each other. And there's no testimony that shows that my client is able to throw knives or anything like that. There's no ability to commit any kind of assault with a knife at that point. When Ms. Coleman decided to stay on the property and get into a physical altercation with my client, that's on her. She wanted to get into a fist fight or a knife fight and she only brought fists. That's on her. There wasn't a surprise. There wasn't Ms. Taylor didn't pull out a knife at the last second. Ms. Coleman walked into this knowing exactly what was going on. She was not assaulted while she was standing on the sidewalk looking up to the house. She chose to continue to engage in this, knowing that Ms. Taylor had a knife. And so the threat, the time that she could have felt threatened or would have felt threatened, it was a knife and she was over 15 feet away from her. That's all I have here. Thank you.
Yeah, it's only brief for about a minute. So Ms. Coleman also testified that she was stabbed after she had fallen down attempting to pick up a can. So in that moment, when she was attempting to pick up that can, there is no possible way she could have posed any threat while on the ground. And again, I would renew my motion, Your Honor.
All right, for having heard this testimony, arguments finds as follows. I heard from Ms. Janine Coleman that on June 12, 2023, approximately 6:30 p.m., she went to 19433 Huntington Drive, City, Detroit. That is the defendant's home. They are cousins. She went there to talk to her about the defendant having posted a Facebook remark or whatever regarding her child. She parked in front. She was with her two daughters. The defendant was in the doorway. She was in the doorway. She had her phone and she had 3 or 4 knives. Ms. Coleman stated that she was standing on the walkway that goes up to the house. Testimony presented that it was 15 to 20 feet away. Discussing the post, conversation became heated. The defendant then escalated this heated conversation by starting to throw canned goods at her. She then picked them up and started throwing them back. And at one point when she went to pick up a canned good, she fell and then exited her doorway, went down to where she was and stabbed her in the leg, which she received medical treatment for. That is assault with a dangerous weapon. She escalated this whole situation. You know, just like Ms. Coleman could have decided, as you said, to walk away. Your client is standing in her house. She could have decided to close the door and go back in her house and not have to deal with it at all. But she didn't. She escalated it first by using canned goods as a weapon and throwing them at it. And Ms. Coleman decided to throw them back. So, we're still in a mutual combat situation. And then your client decided to use one of the knives when Ms. Coleman had fallen on the ground. This is more than enough for an assault by standard of probable cause. Court finds that the felony enumerated in the complaint of warrant did in fact occur in the city of Detroit. Probable cause exists to charge this defendant to be bound over to the Wayne County Circuit Court Criminal Division for bringing on the information, which will be July 24th at 9 o'clock.
July
24th, Your Honor.
Yes, sir.
And I did want to briefly address bond in this matter.
Okay.
Ms. Coleman has indicated to me that since I spoke with her this past Friday, she's received several phone calls from somebody whom she believes to be Ms. Taylor, indicating that she would be contacting Child Protective Services in an attempt to presumably have her kids taken from her being Ms. Coleman. And as a matter of fact, CPS has apparently appeared at Ms. Coleman's address since receiving those phone calls.
What does that have to do with it?
Well, I would like to address bond because she has contacted Ms. Coleman in this matter in an attempt. I should include, Your Honor, Ms. Coleman indicated to me that it was in retaliation for pursuing this case.
Well, you said that she thought it was her. You knew it or she didn't know it. You want to bring her in?
Yeah.
Yeah. Oh, can you step up? You just step up to the table.
Okay.
Ms. Coleman, since this action was brought, have you had contact with Ms. Taylor?
No, I haven't physically had contact with her.
Have you had telephone contact with
Yeah, she called my phone the other day, threatening CPS and all that, and then CPS came trying to take my kids.
her? They did, right?
Huh?
They did not, correct?
No, they didn't.
Any questions based on my questions?
Ms. Coleman, do you have a screenshot or anything of the phone call that you say Ms. Taylor made to you?
Yeah, it's a hidden phone number.
It's a hidden phone number?
Yes.
So you don't, it didn't come from, you don't know if it came from Ms.
I know her voice, yes.
All right.
Anything else, Ms. Coleman?
No.
All right, thank you, ma'am. You step back. All right, so our bond is currently 10,000 personal. What is your suggestion?
The people request that bond be revoked, Your Honor.
Why?
Because
Revoked to do what? You want me to remand her? I mean, what are you asking for?
I would be asked that she be taken into custody so as to not continue to harass Ms. Coleman in an attempt.
So you're asking her to be remanded on a simple assault charge of which she has no history, is probationable, and she's gonna walk out of here anyway. That's what you're asking for?
That's correct, Your Honor.
Okay. Anything, Mr. Wallace?
Your Honor, I have spoken with Ms. Taylor and plan on speaking with Ms. Taylor regarding the no contact order that she has for this. And I can assure you, she will not, she states to me that she's not even the one that made those phone calls. But if in fact there are.
That's a cousin. They know each other very well.
I understand.
Hey, you wanna say something?
No.
Do you really wanna say something to me? You want to keep your mouth closed. And for the most part, your head down, like you got some respect or remorse. Because I will lock you up in a hot second. I don't care that you're a female. It doesn't mean anything to me. I don't care that you just had a baby. That doesn't mean anything to me either. What means something to me is whether or not I can have the confidence that you're gonna follow the orders of this court, which you're obviously not doing. I am not gonna remand her on this. She didn't threaten her. Well, anybody has the right to call CPS on anybody else if they think they have somebody, think they have some violation on it, or that they abused or neglected a child on. So I don't know what's going on in Ms. Coleman's house. To be perfectly honest, Ms. Taylor would know better because we had more contact with her. So am I gonna lock her up? No.
Understood, Your Honor.
I'm gonna make something real clear. No contact means no contact. Now, maybe it was someone else you know. Maybe it was another relative. I don't know. I don't have control over them. I got control over you though. Do you understand that? I gotta hear you. And I will lock you up to make sure that you have nothing to do with it. So she shouldn't be contacted by anybody. Do you understand that? I want to hear you.
Yes, my person's phone.
I'm gonna leave her by as it is. I'm gonna leave her out.
Thank you.
No contact means no contact. You gotta explain what that means. That means you can't contact. Can't have anybody else contact. It's in person, by telephone, text message, email, Facebook, Twitter, whatever. You can't put anything about this incident on social media, any of them. Do you understand that? If I find out you have, we know what's gonna happen, right? Anything else?
Nothing further from the people, Your Honor.
Nothing from the defense, Your Honor. Okay.
The defendant, Matt Cato,
Good to see everybody.
see you, Mr. Wallace. Coming back tomorrow for the motion, right? You don't need the defendants here, okay? Ready?
Yes.
Calling case number 2357523, the people of the state of Michigan versus Fidel Gibson. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons carrying concealed. Count 3, weapons felony firearm. Count 4, lying to a peace officer. 4-year or more crime investigation. Count 5, felony commission with motor vehicle adult advisory. This matter is scheduled for exam.
Good morning, Judge Alex Wing on behalf of the people, P number P86590.
Good morning, Judge. Neighborhood Defender Service by Andrew Sullivan, P84261. Here on behalf of Mr. Fidel Gibson, who's present here in the courtroom. Mr. Gibson, please state your name for the record.
Good morning, Judge, and good morning to the staff. My name is Fidel Gibson.
Thank you. All right, ready?
Yes, the people are ready to proceed. And first witness, they call us Joseph Michael Azopardo. Can we ask for a mutual sequestration to allow the OIC to sit in the courtroom?
Testify?
He's not testifying.
No objection?
No objection, Judge.
All right, do you know witnesses testifying today at trial or any time in the future must leave the courtroom, Zoom, and on YouTube, or be denied their future testimony, with exception to the officer in charge?
Judge, I apologize. I would object if the OIC is going to be testifying in the future as well.
I'll have the OIC step out there.
Okay, I'm sorry.
JOS PPHAZZ
Thank you.
Okay, raise your right hand. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth, so help you God? All right, close the door towards you, have a seat. All right, so you pronounce your last name, is it Azapar?
as a party.
Azapar. Yes. All right, Mr. Azapar, you're gonna be asked a series of questions. First by the prosecutor, then by the defense attorney, and I may or may not ask you questions, all right? You have to answer all your questions out loud using words. Just means shake your head or say, yes, no, whatever the answer is. I'll tell you to listen to the question, answer the question, and stop. So if it's a yes or no type question, just say yes or no and stop, right? I'll have a tendency, well, one, because they need additional information, they'll just answer the question. But we have a tendency when we talk about an incident, especially if that incident is in any way traumatic, we tend to ramble. You know, we want to get the whole story out. We say this happened, this happened, this happened. Right. If you do that, I'm gonna move on. I know nothing about this case. Only thing I know about this case is the defendant's name and what he's charged with. Now I know your name. I get all my information from what happened in court, one question, one answer at a time. That way I can understand. Okay?
Fair enough.
All right, and if you hear someone object or something, you know, maybe ask a question, someone may object or say something, just stop. Okay? I'll tell you what you see. Okay. All right, thank you.
Good morning. Could you please state your name for the record again?
Joseph Michael Azopardo.
And were you at Joy Road, Spinoza Drive intersection, Detroit, Michigan, 48228?
Yes,
And that is in Detroit County, Wayne,
correct.
on the date of 06/11/2023?
Yes.
And what were you doing on that day?
I was driving home.
And when you were driving home, what happened next?
I was stopped at the light at Spinoza on Joy Road. And a red Ford Fusion cut me off. I was stopped at a light. And that car got in front of me under the light.
And what happened next?
At that point, there was the driver was moving around kind of sporadically in the car. I didn't know what was going on and clearly couldn't see the light had turned green. So he was under the light. I was stopped at it. So you can imagine it's directly under.
And what happened next after that?
I tried to get around the red Ford Fusion, and he swerved at me. And then I rolled my window down and he started screaming all kinds of things, saying, people are the problem. We own everything. And I didn't know really what to say. I didn't know how to take that. So I said, you need Jesus. And Mr. Gibson said,
Do you see the person who made those comments to you today in court?
yes. Yellow or beige shirt.
Please let the record reflect that the witnesses identified the defendant.
Record so reflect.
What happened with these, when you were going back and forth with these?
Pretty quickly, within a minute or so, we were at a slow roll at this point. And we were exchanging, and I just told him he needed Jesus, and he said, fuck you and fuck Jesus, and pulled his pistol up.
How do you know that it was a pistol?
I looked right at it.
Can you describe what it looked like?
Just a black pistol.
And after he pulled the pistol out, what happened next?
I hit the brakes and got over behind him, and he wouldn't let me pass him. The entire way down Joy Road, I was doing 3 or 4 miles per hour while dialing 911.
How did it make you feel when he pulled the pistol out and pointed at you?
I thought he was shooting me. I thought I was gonna lose my life.
Then what happened next after you were you driving and him driving? What was happening after that?
I was on the phone with the operator, 911 operator. I gave them the description of Mr. Gibson, his car, license plate number, and where we were. And I just stayed behind him. They advised me to not pass him and just to keep going, just keep my distance away from him. And I had followed him while on the phone with the operator. I followed him to where he had went off into Randall's fruit market.
Did he point the pistol at you the whole time, or did he put it down?
A couple times out the window, but it was, at that point, I was, directly behind him in the left lane. And
it's not legal. I didn't hear anything about him pointing the pistol at him.
Yeah.
Pulled it out. Hold on.
After,
So there's no testimony regarding him pointing it.
After he pulled the pistol out, what happened?
At what point? There was multiple times.
When you were in your vehicle and he pulled it out, what?
The first time he pulled it out?
Yes.
We were side by side, face to face, window to window, both windows down.
And where was the gun pointed?
His right hand, right. If you had someone in your right lane, right next to you, you pointed a gun out your passenger window at them.
Was pointing at you?
Correct. That's when I hit my brakes, got behind him as quick as I could, and dialed 911. The multiple other times were just.
Hold on, wait for the question.
Yeah. Speak to the multiple other times.
That's why we were.
I asked for a narrative.
Slow.
See, hold on. You have to address the question appropriately.
Okay. When he pointed the gun at you.
Objection. What's the objection?
Leading.
It's part of the testimony now. It's not.
Well, I think that that's speaking to the prior instance. I understand the prosecutor is trying to speak to a different occasion.
I don't know what he's trying to. You can get the question out.
Okay.
After the first time he pointed the gun at you, what happened next?
We were heading down Joy Road towards Telegraph Road there, heading west. And he was just gun out the window, the driver's side window, and I was directly behind him. Every time there was a car, any car that approached us, he had got almost in the middle lane and was swerving it everywhere. And I stayed back there and I just followed him until he pulled off into Randazzo's pretty much.
Did you make a call to anyone?
911,
And what did you tell 911?
that he had pointed a gun at me on the road, and that I was following him down Joy Road.
No further questions.
So your testimony, you were driving home, right?
Correct.
You're driving in your truck, right?
My work truck.
That's a 2020 Ford F-150?
Correct.
Is it also a Super Duty?
No.
But it sits up pretty high off the ground, correct?
No.
Your truck doesn't sit high up off the ground?
No.
Okay. You waited in a parking lot across from Randazzo's for the police to arrive, correct?
Where they told me to stop, yeah.
And you spoke to the police about what happened?
Correct.
You told the police that you're a CPL holder yourself, correct?
Correct.
But you didn't have your gun on you that day?
Nope.
You did tell the police, though, that if you had your gun on you that day, it would have been a different scenario.
Correct.
By that, you meant that you might have fired your weapon.
In self-defense, yes.
Fair to say that you were yourself a bit irritated about this attack, correct?
Scared?
That you testified that the Ford Fusion cut you off in traffic,
I was stopped at a red light.
and that irritated you.
No.
It didn't irritate
I
you?
never said it irritated me.
You pulled up next to the vehicle, though, right?
I thought something was wrong, like I said in my testimony to the police department.
You rolled down your window.
Correct, to see if there was an emergency, which is what I asked initially, is there something wrong?
And then you found yourself telling Mr. Cudale that he needs Jesus.
Yes.
And you're telling me today that that when you're saying this to Mr. Gibson, that your demeanor is calm, that you're not shouting at him.
No, I told him he needed Jesus.
And this exchange happens over the course of maybe a minute.
Maybe.
You're driving next to each other.
Rolling, yeah. Just a slow roll, no gas pedal or anything.
But so you're on a 2-lane road, correct?
Correct.
You could have driven around Mr. Gibson at that time and left the scene, correct?
At what point?
Your testimony is that you're driving next to him, correct?
I got next to him for a brief second while we had our exchange, and then I had to get behind him.
And it was your decision not to pull off in front of him
No, I didn't
and
want
get
to get
around.
shot in the back of my head, no.
But before you testified that Mr. Gibson pulled a gun, you could have done that, right?
That's not what happened.
You testified that you're driving next to him for as long as a minute, though, correct?
Possibly.
And you're having a verbal exchange with him for a minute, correct?
Or so.
And in that minute, you could have driven forward. There was nothing obstructing your truck ahead of you, correct?
Other than him swerving at me and then having a pistol in my face, yes.
But you testified that there's this exchange that happens over the course of a minute before he pulls a pistol on you, right?
Brief, yeah.
And you say he's swerving next to you, but there's nothing in front of you, right?
I did hit the curb at one point.
Counsel, I got it. You know,
It's in the.
hold on,
please.
stop. When I talk, nobody talks, okay? Well, I need you to go on to something else, because at this point, it's not relevant. We're talking about something that didn't happen, rather than what did happen. So let's go on to what did happen, please.
Understood, Judge. Your testimony is that he's in the left lane, right?
Correct.
And you're in the right lane.
Correct, for a brief moment.
When the police spoke to you on June 11th, you didn't tell them that you had a verbal exchange with Mr. Gibson, correct?
Yes, I did.
You told the police, when I went to go around him, to talk to him, his gun came right up. That's what you told the police, correct?
No, I told him we had an exchange and then his gun came up.
I'm showing to the prosecutors what I body worn camera from Mr. Officer Mackey. Judge, may I approach?
What are you approaching for?
I have the body worn camera from an Officer Mackey.
No.
That
No,
is
you're
this
not
that
gonna
that
approach
records a
with that.
statement.
No, that's not how it's done. You wish to use this to impeach him, correct?
Correct.
Then it goes on Zoom. It doesn't, you don't approach with your computer, no.
I think I have to lay a foundation
Again,
where I can publish.
You put it on Zoom, you lay your foundation, but you do not approach with your computer. I don't know how clear I can make that.
Okay, Judge, it's just gonna take a few minutes for me to get on Zoom, and I quite honestly, I'm not sure that the resolution is gonna be very good with broadcasting a video. It would be my preference to show him the video. on
Yeah,
my
I don't care what your preference is, counsel. The way we do it now is that if you want to present this video, you put it on Zoom. This is an open court. I don't know who's watching. Someone else can be on Zoom watching, someone else can be on YouTube watching. So they have the right to see it because this is an open court.
Not if I haven't.
It's not a debate. It's not even a discussion at this point. Put it on Zoom or go on to something else.
I'm joining the courtroom now, Judge. Sir, this is you on this video recording, correct?
Correct.
I'm pushing play at 1 minute and
No,
6.
wait, you have to authenticate it. Just saying this is you is not authenticating the video.
Sir, this is a fair and accurate representation of you standing in the parking lot and speaking to the police, correct?
Yes.
And this happened on June 11th, correct?
Yes.
Shortly after the incident that you testified to in court today.
Correct.
Judge, may I proceed?
Yes, sir.
Now pushing play at 1 minute and 6 seconds.
Stop. And he was yelling something at my windows. To go around him and talk to him, his gun came right up.
That came really quickly.
You have to turn the sound on your computer either off or down when you use the sound on the.
When I mute
on
the device,
system.
it also mutes the system here.
So just turn the sound down on your computer. So you have to mute it, just turn it down. Otherwise, we're just gonna get a bunch of feedback and we're not gonna be hearing anything.
something, I had my windows up, and I really seriously thought you had an emergency. It kind of was.
So Judge, again, the problem is that I turn the sound down on my device and it then turns the sound down for the television as well.
Sounds up and totally. Get back to where you started at and hit play, we'll see what happens.
When I went, he got around me and stopped, and he was yelling something, I had my windows up, and I really seriously thought you had an emergency because he kind of was swerving. I'm a paramedic firefighter, man. I'm used to helping people. When I went.
I'll try it again. And I'll...
Can't get it.
No, we got it.
You did get the.
Yeah, the play over there. So you a CPO holder?
Yeah. I normally carry it. It would have been a different scenario had he. I mean, we were door to door. When I went, he got around me and stopped, and he was yelling something at my windows up, and I really seriously thought he had an emergency because he kind of was swerving. I'm a paramedic firefighter, man. I'm used to helping people. When I went to go around him to talk to him, his gun came right up.
Sir, you would agree that your statement to the officer was that when you went to go around him to talk to him, the gun came right up.
At that moment during that discussion, yes,
That was what you told the officer.
at that moment.
So you didn't tell the officer about you rolling the window down and you having an exchange with Mr. Gibson.
I did. It should be on there as well.
At what point did that happen?
What point did what happen?
At what point in the conversation did you start sharing that detail?
I'm not exactly sure. You should have.
Hold on, Council, when you first put on the video playing what happened before he said that.
You can certainly.
Hold on. He specifically said that there was some type of exchange or he was saying something.
And that was before the witness pulled up next to Mr.
No.
Gibson.
That's not what he said. Not what I heard.
I'll move on. Two more questions, sir. Your testimony is that you were afraid for your life.
Correct.
And you continue to follow Mr. Gibson, correct?
Yes.
You followed him to a store where you saw him get out of the car, and you took a picture of him.
I took a picture of the car.
Okay. But you didn't need to flee the scene at that point.
No, I didn't flee the scene.
You felt perfectly safe and
I was on the phone with the police department.
Okay. But you were across the street from him, or about what distance were you from Mr. Gibson at that point?
I didn't measure, I don't know.
Was it 50 feet?
I don't know.
Was it less than 50 feet?
I don't know.
But you were close enough that you could see the plate on his car, correct?
No.
Is that not what you were trying to take a picture of?
No, I took a picture of him leaving.
So it was a picture of him?
Of the vehicle leaving the fruit market.
Okay. I have another question, Judge.
Just a few questions.
Before the defendant pulled around you, did you see a pistol?
No.
And after the defendant pulled around you, did you see a pistol?
Yes.
No further questions.
No further questions with this witness, Judge. All right, thank you.
Awesome. Thank you.
More witnesses?
People call Officer McKee, Robert McKee.
Robert Mack. R-O-T, last name Mack, M-A-C-K-U-I.
Step up, please. Raise your hand. You swear or affirm to the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, pull the door here towards you. You can have a seat, please.
Stay on it. Good morning, officer. Please state your name for the record.
Robert Mackey.
And what is your job?
I'm police officer for the 6th precinct.
Oh, can you step back a little bit?
Alright.
Where do you work at?
Detroit Police Department, the 6th precinct.
And were you investigating on the day of 06/11/2023?
Yes.
And what were you investigating?
A felonious assault.
And when doing this investigation, what happened next?
Supposedly, per dispatch.
Can you say what they said? You received information, and what did you do?
Oh, okay. I received information, that somebody pointed a gun.
Not what the information was, because you received certain information, and based on receiving that information, you did something, correct?
What action did you do?
So we went to Ronald, the Telegraph, to meet up with the victim, in which they said, somebody pointed a gun at somebody who was driving.
Actually, you're saying, since it's been, so it's already on the record, went to Joy Road Telegraph, talked to the alleged victim.
Yes.
What happened next?
Basically, he was stating that,
You can't say what he said.
so what happened next was, he canvassed the area looking for a car that he identified that pointed a gun at him.
What happened next after that?
We made the location of Burke in West Chicago. We observed the red Ford Fusion that the victim stated pointed a gun at him. Knocked at the door. I don't remember specifically the address in my report.
Do you see the defendant who you knocked on the door of the house with?
Yes.
Let the record reflect that the witness identified the defendant being at the home.
You asked him, did he see the defendant? He said yes. You didn't ask him to identify the defendant.
Do you see the person who you spoke with at the home in court today?
Yes.
He pointed to a piece of clothing they're wearing.
I'm sorry?
He pointed to a piece of clothing they're wearing.
Yes.
Point to him and identify the clothing he's wearing.
Brown shirt, white brown shirt.
Please let the record reflect that the witnesses identified the defendant. And when you went to the house, what happened next?
Went to the house, we advised them the circumstances that was going on. Me and my partner gave a pat down for weapons. He didn't have any weapons on him. We looked inside the car due to it was clear tint. Didn't see any weapons. Talked to him about, like I said, advised him what was going on. He stated that he didn't have any weapons, he don't own any weapons, and that he was at Joy Road and Spinoza drove past, and that the victim made racial slurs, and he continued to patrol, ran down to that was off Joy Road Telegraph.
Did you ask him any questions about the pistol?
Yes, he stated that he don't own any pistol, haven't owned it in a long time.
What did you do? Did you determine anything from that?
No, like I said, we ran him and lean. Currently, he didn't have any CPL or any weapons registered to his name.
Nothing further.
Also, just to clarify, you understood that Mr. Gibson was telling you he doesn't own a pistol.
Yes, pistol.
He was specific about that he doesn't own a pistol.
Yes.
But I don't have any other questions.
Nothing further.
Okay, right.
No further witnesses.
Any witness?
No witnesses for the defense, Judge.
The people motion to bond over on all counts except count 4. As it relates to count 1, the victim states that a pistol was pointed at him. As to count 2, going to the concealed weapon, the witness stated before the defendant drove around him, he did not see a pistol. When the defendant drove around him, he did see a pistol. The people motion to bond over on all counts except count 4.
I would join in the prosecution's motion to dismiss count 4, Judge. As to the other counts, I think that there is going to be a difference in Mr. Gibson's version of events when we get to trial. I understand that Your Honor's determination today is only as to a probable cause standard. I do think that the witness has demonstrated some inconsistencies between when he provided the police statement on the 11th, when he gave a written statement, which is more in line with what he testified today on the 13th. So we can bring those inconsistencies to further light at a trial. But Judge, I am asking that you dismiss count 4. I would also like to be heard on bond.
We'll deal with that afterwards.
Okay.
Very well.
The people believe that this is a question of true or fact and that all counts should be bound over except count 4.
All right. Well, in consistency added to that, as the counts 1, 2, and 3 correspond to those felonies that affect the current city of Detroit. I will call this charge defendant. This is now the Wayne County Circuit Court Criminal Division for arraignment on this information. As to those counts alone, count 4 will be dismissed. Arraignment on the information 7/24/23 at 9 o'clock. One second.
Could you give us the date one more time, Judge?
July 24th. What's the issue here as the bond?
Yes, Judge, as the bond, we're just requesting that Your Honor remove the GPS tether. I understand that the state has no objection to that. I do have a letter from Mr. Gibson's employer, which I can provide to Your Honor today if you'd like to see that. He is working at Metro Mobility Transportation Services. He helps elderly folks and people who are not able to drive get to and from employment, physical therapy, things of that nature. Mr. Gibson is 50 years old and has no prior felonies. As you heard testimony today, the police came to his door and he was cooperative. He gave a statement. He allowed them to pat him down and look in his car. So I'd ask that Your Honor, there's been no demonstration that he's trying to evade justice. In fact, I think Mr. Gibson looks forward to a trial in this case. So I'd ask that you just remove the GPS tether and that all other conditions of bond remain the same.
The people have no objection.
Thank you. I said I'll remove the tether then, since the prosecution doesn't disagree with it. Mr. Gibson, do you want to stress there's a no contact provision in your, as to your bond? No contact means no contact. You can't contact the gentleman.
Totally understand, Judge.
Need you to listen for a minute, okay? You can't have anybody else. That's in person, by telephone, text messages, email, Facebook, Twitter, whatever. You can't put anything about this incident on social media. You understand?
Yes.
Nothing further from the people.
Okay, thank you.
Thank you, Judge.
Mr. Sullivan, you're doing the bond.
Yeah, I'm
Okay.
writing order now, Judge.
All right, thank you. Oh,
Yes.
that goes inside that file. Yeah.
Judge, I understand that with the tether, there's a fee associated. Would Your Honor be willing to waive the fee for Mr. Gibson? He is court-appointed counsel. If he's found guilty, he'll be paying court costs. But
I don't know that I can waive it.
I don't know. I'm not aware of any law that prohibits you.
I'm not aware of any law that allows me to either, so.
Well, I feel that the default, that Your Honor should have discretion.
Well, at this point, I'm gonna remove the tether. That's all I'm gonna do. We can address that issue down the road with circuit court, depending on what happens.
Wait for one side.